and we will get started momentarily. All right, it is 10 a.m. on the dot. Good morning, everybody. Thank you for joining us. My name is Sarah Hawk. I am the Executive Director for Joint Animal Services and a board member for the Washington Federation of Animal Care and Control Agencies. I will be your host and moderator today. Joining us, we have Kim Morgan and Lorelei Walker from the Veterinary Board of Governors, and Brenna Annhurst, as well as Kirsten Gregory from Pasado Safe Haven. We are going to be discussing some of the updates to Washington state laws and RCWs, as well as rules that affect animal welfare organizations today. So, few housekeeping. I would like everybody to stay on mute during the presentation so we don't get any feedback. This presentation is being recorded and we will be posting it to our YouTube channel. I'm going to ask that any questions that are being asked during the presentation to please put questions in the chat. As moderator, once the presentations are done, I will start asking those questions. If we run out of time, then we will be taking note of all questions that were unanswered. And we will be compiling any of those unanswered questions so then we can send out any information that we missed or questions that we were unable to answer during this time. And with that, I am going to, we also have Tim Anderson joining us today. Tim is speaking from both a shelter's point of view as well as an animal care and control agency's point of view with the new laws and regulations that are in effect. So with that, I am going to hand the presentation over to the Veterinary Board of Governors, Lorelei and Kim.
Thank you. And I'm sorry, I just had technical difficulties. I got dropped from the meeting and started panicking. Let's hope that doesn't happen again. I am going to share my presentation here. And just make sure that's displaying right for everyone. Okay, I think we're good to go. All right. Thank you so much for having us here. My name is Lorelei Walker, and I am the program manager for the Veterinary Board of Governors, employed by Department of Health. With me is Kim Morgan, our veterinary technician member on the board. And I'm going to go ahead and get us through these slides. I'm going to try to move fairly quickly, saving most of our time for questions. So here we go. A little bit about the overview of the presentation. Sorry, I'm trying to move a window here. Sorry, having a little trouble. Okay, I'm sorry, I'm having trouble moving the window where we are all located. Minimize. There we go. Okay.
We've all been there, trust me.
I know, I'm like,
do not.
Time is of the essence, hurry. Okay, all right, so yes, you'll see the law that authorized the expansion of veterinary services was enacted 4 years ago. The rulemaking to implement that has been a little bit of an adventure, and so that's why it has taken more time. I'll cover some key points from that legislation and then go into the pieces of the rulemaking that implements that law. And then I'll focus most of my time about around the auditing process that's required by the legislation to ensure that services that the organizations are providing are to verified low-income households. And then we're going to try to save at least 10 minutes for Q&A. So it was Substitute Senate Bill 5004 that was enacted in the 2019 legislative session. That bill was, the primary purpose of it was to remove the word limited to those limited services that were authorized in 2002, I believe it was. So that expands that to veterinary care that any registered organization is equipped to provide. A couple of provisions outside of the low income requirement are that any pets adopted to any household can be provided post-adoption care for up to 30 days. And animal shelters are also able to provide emergency care regardless of household income. And then the primary part around rulemaking for the board was the establishment of the annual reporting requirement, demonstrating that our registered organizations are providing that information for the board. Just a note on that also, a question has come up about this allowance of post-adoption care and emergency care. That's not a mandate, that's just what the bill allows. So what didn't change in this bill is low-income household is defined as it has been. This data actually comes from the definition for low-income housing programs. So the Federal Department of Housing and Urban Development uses census data and adjusts for household sizes to give the thresholds of qualifying income. And I've been using the term qualifying agencies, but organizations is really the better overall overarching term. The way the legislation is written, it is animal care and control agencies, although they typically, I don't believe, are ones that are providing, veterinary care to the community. They're mostly the 501c3 qualified humane societies, but they can also be shelters, small scale shelters, animal welfare organizations that are providing those services. And then what also didn't change is the registration that's required with the board in order to provide services. So just a few notes about the rulemaking. This is the second iteration of the rulemaking. The board received some comments kind of late in the game with the first rule and revised it to simplify it, increase flexibility, and really try to implement a least burdensome approach that still meets the requirement of the law. So the big meat of this rulemaking is about how to verify income. That can come through the category of proof of income through income statements. It could be through documentation that shows that the household is eligible or enrolled in a benefits program. And then it also could be the use of an attestation. And the board understands that attestations by far are used the most. And so they, in this second iteration of the rulemaking, offered that more liberally than they had planned to previously. And then the second part of that rule is requiring the organizations to provide documentation that demonstrates that they've verified. So that's what I will get into now. And just a note also, you may have seen it up there, effective June 3rd. So the rulemaking documents for this were filed May 3rd, effective June 3rd. And so a little bit about the process that we are in the middle of. I decided to move this next slides up a little bit in the presentation just to let folks know that the things I'm going to talk about the proposed audit are not set in stone at this point. So coming up in the next couple of months, one thing we need to do is reach out to the registrants that we have and ensure that we have a dedicated email address or email addresses for the contacts that will be responsible for the reporting component. Once we have those gathered, we would solicit comments. We would present to them the information I'm going to present to you in a more detailed format, and solicit comments from those organizations about the draft of the online audit tool, the proposed process and timelines. We would take that hopefully to the board's fall meeting. It might be their December meeting. And once the board reviews it and finalizes the process, everyone that all of the contacts for the registered agent organizations will be provided more detailed guidance about what to expect, how to prepare, contact person with DOH, with the board to help answer questions. And then we'll have time for additional emails before the actual implementation period, which I will get to soon. So data points that, some of the data points that we'll be collecting in this process. I'll go ahead and just let you read those. And then a continuation, so mirroring what is in the rulemaking. The board we would want data that is broken down by how many households did you verify looking at income statements, how many did you verify with a benefits program documentation, and how many did you verify via an attestation. And then this proposed audit process will also ask for sample forms to be emailed separately to program staff at the Department of Health. And the board has been very clear and will continue to be clear. They don't want any identifying information. They don't expect the organizations to be maintaining records that have sensitive information in them. The timeline that is going to kind of work out with how the rule has been adopted. The board has looked at a time frame of July 1st through June 30th of each year. That aligns with the state fiscal year, and that end date of June 30th leaves about a month time before the registration for these organizations is due. That occurs on August 1st of each year. So the board is going to have a lot of time to give agencies to prepare at this point. The first reporting period, if all goes as planned, would be starting July 1st of next year, go through that fiscal year. And the board will provide guidance about that, as that time gets closer. So then the first report due would actually be by August 1st of 2025 for that previous year. And then the board, agency staff will aggregate information, summarize information for the board. They'll look at the data they see, get input from DOH staff and others about any challenges or improvements to make, and they may make adjustments to the process based on the feedback that they get. So I tried to run through that pretty fast. There are a lot of things I missed, but I want to have plenty of time for questions.
And as a reminder, if you have questions, please put them in the chat. That way, one, we can save them, but two, we're not worried about multiple people talking over each other. While we're waiting for questions, Tim, I would like to hear your thoughts on how this is beneficial for animal welfare organizations moving forward.
Yeah, absolutely. One of the things as I've talked to, shelters across the country or been to, conferences or whatnot, so many are shocked that we've not been able to provide services over the years. That is surprising to a lot of humane societies and shelters alike across the nation. So I think this is a huge step moving forward for Washington, and kind of aligns better with what most states are doing. I think the greatest thing for this is really, it's an opportunity for low-income individuals whose pets may never get into a veterinarian to have the opportunity to do that. And I think with what you've implemented or intend to implement, it's not a very heavy lift, right, to verify those incomes. I think those are things that we're all familiar with and pretty simple. So I think I'm excited to see what shelters across our state do with this, and how it's implemented everywhere from Seattle Humane to Tacoma Humane to municipal shelters, Spokane. I think it'll be a great thing for the pets and the people of the state. One of the other things that's really exciting to me is the post-adoption care for up to 30 days. We certainly recognize at our shelter for Regional Animal Services King County that sometimes things happen, and we want to be able to help somebody, and the goal is to keep the pet in the home, right? So if we're able to provide some sort of service within that 30 days, that's a win-win. And we also recognize it's really difficult to sometimes get a vet appointment. Just myself, sometimes, I was used to being able to see take my animals in to see our vet within a week or 2 weeks. And that has been, 30 days. And sometimes during the pandemic, it was much longer than that. So I think this is a huge step forward for the people and the pets across the state. And I know there's probably lots of questions people have. I'm looking in the chat box there and I see like 9. So I'll be quiet and let them get some of the questions in.
So first question is from Laura Clark from Whatcom Humane Society. So she asks, in theory, Could a private practice vet using their licensed partner with a local shelter and offer services without the low income requirement?
I was reading through this one and gears in my head were turning. This is a little bit more complex of a question. I from what I've heard there, there are practices where there will be like a vaccination clinic or a microchipping clinic that's open to all. And I think there are scenarios where that's fine. I may need to kind of think on this one a little bit more about sort of the legal framework around it. The whole thing around allowing a humane society, I believe it ties to law in Washington, the corporate professions. I can't think of it right now. I know the RCW number, but basically saying that to provide veterinary services, a clinic or a business must be organized by veterinarians. So to allow these services, it's kind of a carve out of that Professional Services Act. So then it gets a little more complex to think about a private practice veterinarian partnering with the shelter on site, the shelter. So maybe think about that one and get some more feedback later.
Next question is from Christopher Ross, Seattle Humane Society. Can you confirm the AMI is calculated by the county where the shelter is located, or is it where the resident lives?
Yeah, that's an interesting one. It's the oddity. And Kim, I don't mean to just kind of take over.
No, please do.
Chime in if you'd like. It's an odd one because the definition for income, again, it comes from those housing projects. I used to work in low income housing projects. And you think about where the project happens is someone's house. You go and weatherize someone's house or, provide rehabilitation services to their house. So that is an oddity of this, and a concern that I've definitely heard is the county is where the project happens. So it's where the shelter or organization is located. And we understand that creates issues for someone crossing a county border to, get services rather than getting it in the county in which they live.
Wow.
Next question is from Kathleen Olson of Perfect Pals, and she's also president of WAFED. She appreciates that this allows organizations not to keep our low-income clients' personal information on file or share it. This was a big issue as this was developed. Did you have any other issues like this that came up?
I'm happy to speak to it unless you want to, Kim.
As usual, be my guest.
Okay. I mean, yes, that was definitely one, was the keeping of sensitive information and the staff work and staff power and resources taken away to do that. The other big conversation was just a really good conversation that the board needed to have about looking at this more through social justice and equity lens. And so a big part of that was about reducing stigma, reducing the barriers to providing services. And that's why the attestation, which was previously limited to those participants that literally had no documentation to show, most often would be the case of not having housing security. So the board opened that attestation up much more broadly for that reason. That's the major other issue.
And a final question before we move on, would you be able to share the dates again? So the slide that had the dates dating back to June 2023, would you be able to share that again real quick?
Yeah.
I think I'm just going to add real quick on that previous is that the board decided they wanted to eliminate as many barriers to care as possible.
Is my screen big enough for you to see? Is that in this format? Is that okay?
Yeah, this is great.
Okay. So again, looking at the state fiscal year, which runs July 1st through June 30th, there's no way we could tell organizations now, hey, start collecting information as of July 1st, because we're still working through, getting feedback on the implementation. So the idea would be that data collection would start July 1st of 2024, would be collected through that year, and then reported by August 1st of 2025, which is the renewal date for the registration.
Gotcha. Can you give counsel on what we should be doing in this interim year before this actually goes live then? Just
Yeah, and I will say, really once that legislation was in place in 2019, that law allowed organizations to provide full veterinary services. I definitely did get inquiries at the time of like, well, what do we do in the meantime? And you know, I said, yeah, the law authorizes you to do this, but until the board can sort through the administrative rulemaking, you know, stuff around it, keep doing what you've been doing in terms of, you know, what your processes have been to verify income. So I think that's all we can say. We can't say, oh, in the meantime, kind of do as much as you can of what we're saying here, you know, just keep doing what you're doing, and then, you know, give us feedback as we start communicating out a little more details about the plan.
gotcha.
Fantastic, thank you. I am going to bring this portion of the legislative update to a close, and invite our next guests to present. We have two different topics that we're going to be talking about. First is the new law for HB 1234. Which talks about seizures in animal cruelty and neglect cases. And then after that, we will be talking about the new law around protecting consumers with pet stores. So please take it away.
Hi, good morning, everybody. Right on cue, my dogs are barking at the squirrels, so I apologize if you're barking in the background. I'm Kirsten Gregory. I'm General Counsel for Posadas Safe Haven. And we're here with Brenna to give you an overview of HB 1234 and 1424, and what you guys need to know to operationalize the changes that these laws that will come into effect on July 23rd from both of these laws. So I'll dig right into it. HB 1234 is an act relating to the civil forfeiture of animals seized for abuse or neglect. The bill adds a new section and substantially rewrites RCW 1652-085, which governs seizure, forfeiture, and cost of care bonds for animals involved in animal cruelty investigations. It was unanimously passed by the Washington House and Senate, and the changes go into effect on July 23rd. A little bit of background on the statute. You can see there the areas that the statute governs. The statute was enacted in 1974 and had been amended 6 times prior to HB 1234. It was, I think, universally seen as ambiguous, poorly organized, and containing many gaps. We saw a lot of inconsistent and contradictory interpretation and application between jurisdictions. And some jurisdictions just decided not to use the law due to concerns of litigation risk. So based on feedback solicited by WACA from its members, it was consistently at the list of top of the list of statutes that needed to be overhauled to improve day-to-day handling of cruelty and neglect situations. So we worked with a lot of different stakeholders and WACA prosecutors, both civil and criminal prosecutors, to overhaul this statute and hopefully make it a much better tool for everybody involved in the process, from animal control, law enforcement, prosecutors, to judges, and also animal owners. What's new in the statute is there's a statement of legislative intent, and this is pretty important in terms of reducing litigation risk and also defining and stating exactly what the legislature intends with this statute. So these tools of seizure, forfeiture, and cost of care bonds do not conflict with the presumption of innocence. It's a civil remedy. Seizure, forfeiture, and cost of care bonds are used by the state to satisfy its interest in mitigating the suffering of animal victims. And the act is a means by which a neglected or abused animal may be removed, protected, cared for, and disposed of appropriately and humanely. Also importantly, this statute does not apply, the civil asset forfeiture laws and rules do not apply to the forfeiture of animals. Also new is a definition section. It's important to note that these definitions only apply to this particular section. They do not apply to other parts of Chapter 1652. There's a definition of minimum care that applies only to agencies and their agents. That's humane societies, shelters, or rescue organizations that are caring for seized animals, and defines the care that those agencies must afford those seized animals. There's also definitions of physical infirmity, physical injury, and serious physical injury or infirmity. And these definitions apply to when an animal may be seized without a warrant. And we'll get into that more specifically a little bit later on. So, all right, jumping right into seizure. As has been the case, an animal may be seized with a warrant, where there's probable cause to believe that the owner has violated 1652. And there's also, and this was in the current statute, but not as clearly as it's now laid out. You may seize an animal with a warrant if there's probable cause to believe that the person owns, cares for, or resides with an animal in violation of an animal ban or a court order. And an important note on this: an animal seized from a person who is in fact in violation of an animal ban or a court order, those animals are immediately forfeited to the seizing agency by operation of law, and no court action is necessary for that transfer of ownership. So those animals are immediately available or owned by the agency and available for adoption, or be able to be put up for adoption. Also, there's a lot more detail now in the statute regarding seizure without a warrant. So the statute says that if there is probable cause to believe an animal is in imminent danger, is suffering serious physical injury or infirmity as those terms are defined, or needs immediate medical attention, then an officer may enter onto private property without a warrant to either render emergency aid or seize the animal without a warrant and immediately bring the animal to a veterinarian. Some other things to note about the seizure provisions. There is no prohibition against or specific requirement for the use of vets. So that provision that is in the current statute is now gone because the statute does not address it. The use of veterinarians or other outside resources or experts during searches and seizures is left to the needs and judgment and individual policies of the officer or agency. We saw conflicting interpretation and confusion around the vet requirement. So that's just gone, and that's left to your judgment and policies, how you use that. There is no requirement that the officer make a good faith effort to contact the owner before the animal's removal. It's not prohibited and it's not required, again, up to your discretion, judgment, and individual agency policies. Officers who enter private property without a warrant under this section are immune from liability for damages if the officer does not use any more force than is reasonably necessary. So there's protection for officers that are going to render emergency or life-saving aid for animals in dire situations. So once the animal has been seized, the statute talks about what can happen with that animal. The seizing agency may place the animal with a humane society, an animal sanctuary, or a nonprofit rescue. Also, it specifies that the animal may be placed in foster care that is not associated in any way with the owner. You may have some questions about that. We do operate an evidence foster program. We work with agencies to place evidence animals into foster care with foster homes that are trained in chain of custody and other considerations. So that is a possibility that your agency may want or organization might want to consider. And we can provide some additional resources about that if you're interested in exploring that. In determining what is a suitable placement for an animal, the officer shall consider the animal's needs, including its size, its medical needs, and its behavioral characteristics. So for instance, you may have an animal with significant medical needs where the shelter situation may not be an ideal situation. And so a smaller rescue or other nonprofit organization or even a foster home may be a better placement for that animal. Wherever the animal is placed, the seizing agency retains constructive custody of the animal and has a duty to ensure that the animal receives minimum care. While the animal is in its placement, the agency may draw funds from the bond and distribute to the Humane Society, Sanctuary, Rescue, or foster those funds to cover reasonable costs actually incurred to provide minimum care. Now, so once the seizure has happened, the next thing that an agency needs to do is provide notice to the owner of the seizure. Their written notice must be provided within 72 hours after the seizure. There's some changes here. That 72-hour time, 72-hour period is a change. The notice can be posted at the place of seizure. It can also be delivered to the last known or suspected owner in person. That's a slight change. And also could be delivered to a person residing at the place of seizure, or sent by registered mail to the last known or suspected owner. Again, a little bit of a change there. And then section 2(4)A through E contain a detailed list of what the notice must require. We have some resources and a checklist that I'll share with you about that notice form. It's a little too detailed to get into here. The most important thing that I want to mention, and that I think may trip some folks up, is that the statute has a form owner's petition template at the end of the statute, and that form must be attached to the notice. And so also we have some resources to share with you about that, but it's important to get that form attached to the notice when it is posted or delivered or sent by registered mail. So the next topic the statute addresses is cost of care bonds. It's important to know that the owner of a seized animal must post a cost of care bond to prevent forfeiture. And the amount is a amount sufficient to provide minimum care for each animal seized for 30 days, regardless of whether criminal charges have been filed. And there's a definition of animal included in this section only. Animal in terms of the cost of care bonds, it includes unborn offspring and offspring born after the seizure. So the bond must be enough to provide minimum care for a litter of puppies that is delivered after the seizure, in addition to the mother dog. The venue, this is a new requirement. Previously, the statute did not say where the bond must be posted. Now the statute specifies the bond must be posted with the clerk of the district court in the county from which the animal was seized. The big change here is the deadline. The bond must be posted by 5 p.m. on the 14th calendar day after the day the animal was seized, or the animal is forfeited by operation of law. That means no further court action is necessary. And importantly here, if bond is not posted, but an owner has filed a petition for return, animal is forfeited. Bond is a requirement whether or not a petition for return is filed. So next we'll jump into a little bit more on the cost of care bonds. Again, like I said, the agency may draw from that bond to cover its actual and reasonable costs. And if a bond has been posted, all subsequent court proceedings, the civil proceeding and any criminal proceedings, shall be given court calendar priority as long as the animal remains in agency custody. That's to keep the bond that their owner is responsible to as low as possible, and also get the animal moved through the system as quickly as possible. There are also new provisions regarding bond renewal that are very clear and clearly specify that if the bond is not renewed in accordance with the statutory requirements, there is, again, automatic forfeiture by operational law upon the expiration of the renewal deadline. So no court action is necessary. Animal becomes the agency's property and can be made available for adoption. An owner, there's a lot of changes here regarding the owner's petition for immediate return. No change to venue, as has been the case under the current statute. Venue is still with the district court in the county from which the animal was seized. Big changes again around deadline. That petition must be filed with the district court by 5 p.m. on the 14th calendar day after the day the animal was seized, unless a bond has been posted. If there's no bond and no petition, again, animal is forfeited by operation of law. And the owner must serve a copy of the petition on the agency and the prosecutor. If a petition is filed, then the court shall set a civil hearing to be conducted within 30 calendar days of the filing. So hopefully we'll get those hearings happening pretty quickly after the filing of the petition. The statute makes clear that the hearing is a separate civil proceeding, is not combined with a criminal proceeding, and that the rules of civil procedure will apply. The burden of proof is shifted to the agency, and the burden is to establish probable cause for the seizure, and that existed at the time of the seizure. So the burden is shifted, but the burden is also pretty low. If probable cause for the seizure is established, the court shall order the owner to post or update the bond within 72 hours, or the animal is forfeited by operation of law. And if probable cause for the seizure is not established, the court may order the animal returned to the owner subject to conditions, and also order a refund of all bonds paid and reasonable attorney's fees to the owner. These are some due process rights that were added by the our sponsor of the legislation during the legislative process. Other provisions that I want to make you aware of: disposition after forfeiture. The agency may place the animal with the new owner, but may not place the animal with family members or friends of the former owner, or anyone that lives in the same household as the former owner. So there's some degree of due diligence that an agency must do regarding the adoption out of that animal. Euthanasia is permissible for humane reasons at any time, just as it has been in the past. And voluntary relinquishment is not impacted by this statute. The statute does not prevent voluntary permanent relinquishment by the owner, and that relinquishment has no effect on the criminal charges that may be pursued. If there is a relinquishment, criminal charges may still be pursued. Also, none of the provisions of the statute impact an agency's ability to take care of custody for or properly dispose of stray, feral, at-large, abandoned, or wild animals not kept or owned as livestock. The immunity provisions, the new provision that regarding officers who enter a property without a warrant, we already talked about, and then the current immunity provision still exists and is expanded slightly. So that's a lot of changes. We understand that, and we have provided, we've created a web page to hopefully help folks get their arms around these changes and then implement them. So you'll see there's a QR code there to our web page, and on that web page you will find a notice of an owner petition form template that has been reviewed by various subject matter experts, and we hope to have that actually a template approved or endorsed or given the thumbs up by WACA. So we're working on that, but for the time being, we've got a petition there that we believe meets all of the legal requirements. Also, if you want to create your own notice and petition form, we have a checklist available. And so you can take that checklist and create your own form, be confident that it's meeting the legal requirements. Then there's a general overview of the statute with citations. This is sort of your quick reference guide that outlines the topics that we've gone over here, but not in quite as much detail, and then provides citations to the statute so you can look at those yourself. Right now, the statute, if you look at RC 52085 on the legislature website, on the state website, you'll see the old statute with a link to the bill. That's pretty confusing if you look at the bill because it's got all the additions and deletions and all these line throughs. So we've created a clean copy of what we think the statute's going to look like after all those additions and deletions are accounted for, so that you can take a look at that as a clean copy of the statute that will go into effect on the 23rd of July. And then we'll update that link as soon as the state has an actual official version of the new statute. There's also an overview presentation similar to the one we just gave here that was previously given to PAW. And so we'll update that with this presentation, so you'll be able to download or look at that presentation, the presentation slides there. And then this next, the bottom right, is probably, I think, the most important, and it's a side-by-side comparison of the statute before and after the changes. So this is what that's going to look like. It's a breakdown by topic and area. It has every sentence of the current statute compared with the corresponding sentence of the new statute. I've added highlighting throughout to draw your attention to certain important changes, and also added some notes there to help sort of guide you to what the important changes are. So you'll be able to download that, and you can see side by side old statute versus new statutory provisions. And then let's see. Okay, the next thing is feedback. We want it all the way across the board, the good, the bad, and the ugly, related both to the new statutory provisions from HB 1234 and what we might want to change and tweak going forward as you guys get experience implementing this statute, what's working for you, what's not working for you, what is confusing, what could be improved. We know it's not going to be perfect right out of the gate, and so we're committed to going back and improving it if there are areas where we think it needs it. Also, if you have any feedback on any of our resource materials, please, we'd like to hear those. And we'd like to hear all of your questions. I would say that we solicited a lot of feedback during the legislative process. And there were actually amendments made to the bill after it was first introduced based on feedbacks from both WACA and WAPA members. A lot of that feedback was incorporated into a revised version of the bill. One thing that I would note was not incorporated that we suggested and asked legislative staff to consider was the venue for the petitions. We asked them to look at whether it would be appropriate to also include municipal courts as an appropriate venue. That did not get addressed by legislative staff or picked up in the bill, but something that we know is an interest to folks. And so we'll look at that going forward as a potential change. And then I will turn it over to Brenna.
Hi, everybody. Good morning. So my name is Brenna. I'm the Director of Education and Advocacy at Pasado Safe Haven, and I'm going to be doing an overview of House Bill 1424, which is an act relating to consumer protection with respect to the sale and adoption of dogs and cats. So this bill that passed is basically looking at the intersections between puppy mills, retail pet stores, and how that relates to consumer protection for Washington residents. This bill amends a number of sections in RCW 1652 and also adds a couple of new sections to some other chapters, and those sections are mostly relating to financial agreements and installments for the purchase of dogs and cats. So this bill did pass the Washington legislature with bipartisan votes in both the House and the Senate, and was signed into law by the governor on May 1st and will go into effect on July 23rd, which is 90 days after the end of the legislative session. So a little bit of background on this issue, and I'm sure that a lot of people on this call are very familiar with the issues between puppy mills and retail pet stores. But this is something that Washington has been working to address for quite some time now. Starting in 2009, there was a bill that passed that basically addressed the issues with commercial dog breeders, making sure that there was requirements that those commercial dog breeders had to follow in order to meet Washington state dog breeding standards. Now, the main issue with this law that passed in 2009 was that commercial dog breeders that were licensed by the USDA prior to July 2010 were exempted from the provisions in this law. So that was a big loophole that was part of that law as passed. And then in 2019, people became aware that a lot of retail pet stores across the country, including in Washington, were starting to use lease agreements for the sale and transaction of dogs and cats at pet stores, and basically using dogs or cats as collateral in these consumer lease agreements. So in 2019, a law was passed to prohibit the use of these lease agreements. So basically kind of looking at the issues, the known consumer protection issues that retail pet stores were posing. And so that was the beginning of really looking at how we can address the issues between puppy mills and retail pet stores. In 2021, we were able to get a new law passed, which again strengthened the laws around retail pet stores selling dogs and cats. So this law, as passed in 2021, basically made it so no cats could be sold in retail pet stores, and it made it so that dogs could be sold in pet stores as long as the pet store was in operation prior to July 2021. So it basically made it so that the issue could not get any worse, and basically left it within a handful of pet stores that were still in operation in Washington, still selling dogs. Along with these state laws that have passed, there have also been a number of municipalities that have passed ordinances prohibiting retail pet stores from selling dogs and cats, or heavily regulating the sale of dogs and cats in these pet stores. So this is a high-level overview of what House Bill 1424 achieves, and I will be going into a little more detail on each of these bullet points throughout this presentation. But basically, this law, as passed, continues to codify that no new pet stores can open and start selling dogs and cats. So basically maintains that law that passed in 2021. So cats can still not be sold in pet stores, any pet stores, regardless of when they were first established. It also creates some really important transparency requirements for pet stores that do sell dogs in their premises. And so these disclosure requirements basically are around the price, the source of the puppies, and the licensing numbers of where those puppies are coming from. It also closes that loophole that I mentioned earlier in Washington's commercial breeding law. So basically it removes that exemption that allowed Washington breeders to that were licensed prior to 2010 by the USDA. It also will prohibit the use of consumer leases, retail installment transactions, and loans for the purchase of a dog. So what we did find is, even though we had that law that passed in 2019 that addressed those lease agreements for puppies and kittens, pet stores were getting around that by using third-party financial institutions, mostly from out of state. So they were getting around our Washington laws and continuing to use leases and other financial transaction plans to sell their dogs and cats for very, very high interest rates. This law also will impose a monetary penalty of $250 for stores who are in violation of this new law. And this law does clarify that local governments can continue to impose stricter regulations on retail pet stores in their jurisdiction. So here's a closer look into the new requirements for retail pet stores that sell puppies. So the sale must occur at the same address as the pet store's license. Also, any dog that is sold must be obtained directly from a breeder in compliance with Washington State's commercial dog breeding law, and the RCW for that is 1652-310. Pet stores can also source from USDA licensed brokers, and we know that one of them in particular in Washington does do that, but they do have to prove that that broker is sourcing from breeders who are meeting Washington state standards. All advertisements have to include the supporting documentation. So that's the consumer transparency materials that I mentioned earlier. So this supporting documentation has to be in a visible location at the store, and also has to be provided in written form to the consumer. This supporting documentation has to show that there is compliance with the Washington State commercial dog breeding law. It also has to include inspection reports from the USDA for the previous 3 years, and that has to be held at the pet store for a minimum of 5 years. Also, a big requirement that is placed on pet stores now is that there is a minimum age for the dogs that they are allowed to sell, and that minimum age is 8 weeks. Prior to that, there was no minimum age that was a requirement for pet stores. Also, in terms of consumer protection, pet stores now are required to post the price range for the dogs that they have for sale. This is a really big change for pet stores. A lot of their tactics are to bring people in, and when they get people into that kind of emotional state, when they have a puppy in their arms, then they hit them with the cost of that puppy, and it's really hard for people to say no in that moment. So having this price range listed for the consumer to see prior to the purchase is really important. They also have to provide the federal or state license numbers for the breeder or the broker, and then they have to list any violations that that breeder or broker has with our federal and state laws. So that loophole in 1652-310, so our commercial dog breeding law, so that loophole has now been closed. That means that all commercial dog breeders in Washington are now subject to our state requirements. One of the things that makes Washington's dog breeder laws stand out amongst other states is that we do have a cap on the number of unaltered dogs over the age of 6 months that can be in a dog breeding facility. This cap of 50 dogs that are unaltered is a really important number to have, because it allows for a really easy way to determine whether or not a facility is in compliance with this law. And unfortunately, in the statute, there is no clear definition of what a commercial dog breeder is. However, if you look into the details, it does specify that if a facility has more than 10 unaltered dogs over the age of 6 months, then they must meet the defined enclosure and housing requirements at that facility. So basically, the definition, though not clearly defined, can be seen as any facility that has more than 10 unaltered dogs. All of these commercial facilities, of course, must provide easy and convenient access to adequate amounts of clean water. And these facilities also must provide veterinary care without delay when necessary to those animals. A question that has come up and might be of interest to people on this call is how does this relate to adoptions? So retail pet stores can still partner with animal care and control agencies or rescue groups. And this is so that they can showcase animals for adoption. Now, when we say showcase animals for adoption, this means that that rescue group or animal control agency, they still have ownership of the animal, and they are the owner of any transactional agreements for an adoption of an animal. And that makes it so that that retail pet store does not have any financial interest in that animal. So it kind of prohibits the ability to basically use false or sham rescues as a guise to still continue to sell puppies at really high rates. To aid in the transparency for consumers, these pet stores must, of course, have a label that says where that animal is from, so the name of the rescue group, and also have the address of that rescue group so that people are aware of where that animal is coming from and where that adoption is taking place. All right, in terms of enforcement, so for the pet stores, it is now a Class 1 civil infraction for a pet store in violation, and the maximum fine of that is $250. So this civil infraction can be served to the pet store's registered agent, so that is the owner of the pet store, and animal control officers can investigate and enforce the provisions in this law. So any retail pet store that is in violation of this section 3 or more times over the course of a year will be completely prohibited from selling any dogs. So it's basically like three tries and you're out, basically. Nothing in this section, I mentioned this before, but nothing in this section prohibits a city, town, or county from enacting stronger regulations or basically banning pet stores from selling dogs and cats in their jurisdiction. So that's a really important thing to note, that any municipality or county that has a pet store that is still selling puppies can enact some stronger rules and regulations for that store. Now, for breeders, basically the enforcement and the penalties is still the same for this section, but any person who violates this section, which is having more than 50 intact dogs or not meeting those standards of care that is outlined in the section, is guilty of a gross misdemeanor. All right, and then this is questions for both House Bill 1234, which Kirsten covered, and House Bill 1424, which I covered.
And while we're waiting for everybody to input their questions, Tim, I would love to hear your opinion on both of these bills.
Yeah, absolutely. Let me start with 1424. I'll tell you, in 2018, I went to a neighboring county that had a pet store that was selling, essentially financing pets, and I was shocked how it was almost like buying a car, the entire process, right? The first thing that happened is we were in a line and they were checking my ID, which I thought was strange to begin with, and went in and I see people that were picking various puppies off the floor, and they were allowing them to hold those puppies. And before you knew it, people were up there and essentially purchasing, like financing a puppy. And I could hear a lot of people that were talking about, oh, they just had their tax return or whatever it might mean. And I thought, well, this is not what it's supposed to be like. This isn't what it should be at all. And so I was happy when the legislation came into 2019, but then surprised to hear in 2020 from some of the members of WACA who had gone in and seen that practice was still happening. So I'm glad this closes that loophole, that ability for them to find financing or, some sort of out-of-state workaround. So that's a fantastic. And I think, that law 1424, to Brenna's point, is it's protecting the pets and the consumers as well. And I think hopefully the end game is that we just won't see it anymore. I think there's a handful, I don't even know, I'm sure Kirsten and Brenna know of pet stores throughout the state that still sell pets, but we see more and more getting away from it. So I think that's a good thing. Sarah had her hand up. How many was that, Sarah?
2.
Oh, 2. Okay. Yeah, so that's great. And I know in King County, at least in our areas that we cover, there isn't any longer. The last one just closed up recently. So and then House Bill 1234. Thank you, Posados. Thank you, Kirsten. She has done an amazing job on this. And I know there's so many people that have given feedback, both our membership, our board, our prosecutors, just anybody that they can think of an amazing job. This is probably one of the best pieces of legislation I've seen in my career, and cleanup. And it was so needed. To say that it was ambiguous just feels like an understatement. It was an absolute disaster. I've been trying to sort out what the law meant, everybody's individual interpretation of it, how it was implemented by agencies and courts across the state varied. Some, as Kirsten spoke to, just didn't even use it at all. It was a good tool, but it was ambiguous and very problematic. I think this is probably one, as the president of WACA, that I would frequently get calls about. How do we address this? How do we use it? It was underutilized, as well as people that just wanted to clean it up. So you took on a huge project and did an amazing job. Some of the pluses, I think, for agencies out there are the bond requirement and petition. That's very clear now. So it is both of them together. There were agencies in the past that I know people would post a bond. What did that mean? What was the process? What happened next? What happened when the bond was up in 30 days? And then there was different rulings from different district courts. So very, very confusing. So I I'd say one of the biggest changes that I truly appreciate from our agency is changing, and Kirsten didn't cover it, but going from business days to calendar days was huge. Because really, when you look at what calendar days was, that was at least 21 if not longer, days that we would be holding on to an animal and incurring the cost for it while someone decided if they were going to petition the court or what that course of the action was. Typically, my experience petitioned the court in the past, but when we did have someone that would post a bond, it was just even more ambiguous and scratching our heads figuring out what to do. I've heard from some people since concerned about the shift of the burden of proof away from the pet owner to the agencies. I think that's actually a really good thing. Oftentimes people come to these petition hearings not represented by an attorney, and that was also very complicated because they were trying to show a burden that the animal was not going to be caused any further harm, and it just didn't make any sense. So that shift in burden makes sense. I can't say enough. I mean, everything in here is great, and I'm sure we'll probably find some things that need tweak as we move along. But the initial reactions that I see from members and people from across the state is all positive. And I couldn't tell you enough, Kirsten. Thank you so much. It was definitely needed. I actually was very excited and started our seizure notice right away, and then the next day I got an email from Kirsten, so she had started or completed one already. So I have great resources. Not only this is a great piece of legislation, I'm excited how this is rolling out because we don't often see that. I think with the help of Posados, there is a lot of structure. So here are the things you need, here are the things that have changed. It's going to be really, really good. And I think hopefully people will give feedback. I also encourage anybody who is here from an agency to be reaching out, being proactive with your district courts. I've already reached out to our district court to make sure that they understand. They may not be aware of these law changes and it is going to impact them. So making sure that they're on the same page will be a win-win for everybody. And lastly, the ability right after seizure to put an animal into, foster or rescue or where it might be is huge too. I think I could speak probably for Sarah and ourselves, taking in 100 animals at a time when we're already facing, high census numbers, having another option where we can place those is great, and the ability to pull from a bond is also very helpful. I know Sarah had 170 some odd cats recently, Sarah, so
159.
yeah, so imagine when that happens in August, post this law change. I think it'll be much better for all of us involved. So, and I know we're kind of short on time because we're right after 11, and I see there's questions coming in, so I will end it right there. But thank you so much. I really appreciate it.
We
Yes.
actually, the one question that we had was from Brandy. She wanted to know if any animals in current custody could be applied to this new law. And I don't believe that they can. It would be anything after the new law goes into effect, correct?
So I would be interested to see if, I have not done the legal analysis on that. I'm not sure if somebody has. I would say that that can be a tricky evaluation or legal analysis on whether something has a retroactive effect. But I would say that because this is clearly labeled as a civil remedy and is in the best interest of the animals, float this by your attorney and ask for an opinion on this. I don't fully count it out that it could not be applied to animals that have already been seized, but I can't say that it would for sure either. We'll do some more digging into that, but that's going to really come down to your prosecuting attorney or municipal attorney's interpretation and comfort level with doing that. So check into that, Tim.
And to
I was
wrap
gonna say-
things, oh, go ahead, Tim.
I was just real quick, and Brandy, if you have success with the city of Seattle, let us know. I just pitched on the seizure we did. It did not go well for me. So if you have, if you get some movement, please share that with everyone. You can reach out to Sarah or I. That'd be
Okay, I'll put that on my to-do list to get that legal research done ASAP.
To finish things out, we didn't have any more questions come into the chat. For those of you who had to hop out or want to, review what you've just seen, we are going to be, since this was recorded, this is going to be posted to our YouTube channel. We're also going to put it on our website along with the slides for you guys to review. And we will also be providing a link to the resource page on Posados as well, as helpful to get all the resources out. If you enjoyed today's presentation, please fill out the survey in the link, or if you didn't, I want to hear that too, so we know what we're providing you guys in the future. If you are not a member of the Washington Federation for Animal Care and Control Agencies, I would encourage you to look into that and do so. I have provided the link in the chat. There are many benefits for your organization in becoming a member, and one of these are legislative updates such as this throughout the year. So thank you everybody for attending. Thank you so much to our presenters today for taking time out of your day. We greatly appreciate it, and have a wonderful Friday, everybody.
Thank you. Bye-bye.
Thanks, everybody.